Hello students, welcome to Legacy as Academy. In today's video, we are going to discuss about the recent decision that has been taken by the Supreme Court of India, where it has dismissed the review petition that was filed regarding the same-sex marriage and the legal recognition that should be provided to the same-sex marriage in India. So in this context, the Supreme Court has dismissed the petition and it has stood by the judgment the Supreme Court made in the October 17th, 2023. While rejecting the petition, it has clearly stated that basically that the petitions found no error apparent on the face of the record of the majority view in 2023 ruling, and since there is no error apparent, there is no ground for the basically submission of this particular review petition. Now before going further, let us try to understand about the review petition. Now under Article 137 of the Constitution of India, the Supreme Court has the power to review any of its judgments or orders. And review basically means that when court re-examines the decisions made by itself, it rectifies the error in an act, judgment or legislation. And there are three grounds for seeking review. First is the mistake or grave error apparent on the face of the record, if Supreme Court believe has happened in its past judgment. Second, the discovery of new and important matter of evidence that might have changed the entire matter of the particular subject. And third, any other sufficient reason, as we have seen in the case of Chhajju Ram versus Neki, where Supreme Court has admitted the petition. Now, what was the basically judgment about? The judgment refers to the judgment that was given by a 5-judge bench in the 2023, where citing institutional limitations, the court has declined to strike down or tweak provisions of the SMA, that is Special Marriage Act 1954. While doing so, it has ensured there is a no unqualified right to marriage. Basically, at that time, the justice have said that as far as the right of marriage in India is concerned, it is a qualified right, not unqualified right. What basically it means? Unqualified right refers to such kind of right which need not be balanced with the right of the other section of society. Second, it has said that the same-sex couple could not claim it as a fundamental right as guaranteed under the Constitution, and it also has rejected the prayer to grant legal recognition to the same-sex marriage. Bench said that this is not a job of the court, rather the decision regarding this should be taken by the Parliament by passing or through enacting a legislation. So this is something that the current judgment also agree with, and in this context, the justice have said that we have carefully gone through the judgments delivered earlier and do not find any error on the face of the record. However, we find that the view expressed in both the judgments is in accordance with the law, and as such, no interference is warranted. Accordingly, the review petitions are dismissed. So, in 2023 ruling, if you try to understand, there were two views. One was the majoritarian view and other was the minority view. Majoritarian view was that the right to civil union or right to enter into abiding cohabitational relationship is something that cannot be considered as a fundamental right. While at the same time, the Chief Justice of India, D.Y. Chandrachud, at that time has said that it could be traced to Part 3 of the Constitution and thus placed a positive obligation on the states to accord recognition to it. And at the same time, it basically, if you try to understand the essence of the judgment, Supreme Court has refused to tweak SMA to recognize same-sex marriage, says only legislature can do it. CJI and Justice Call say right of queer couples to enter into civil union flows from Part 3 of the Constitution, but majority differs. So his view was minority view, and that is why judgment was not passed in this context. Now the majority ruling suffered from the errors apparent on the face of the record and was self-contradictory and manifestly unjust. It said that the majority judgment was erroneous because while it found that the respondents were violating the petitioner's fundamental right through discrimination, yet it failed to enjoin the discrimination. That is why the review petition was largely filed here. So what has been the petitioner's argument in this context? Now the majority judgment overlooks that marriage at its core is an enforceable social contract, and also the right to such contract. Social contract we talk about in simple terms, we can understand it is nothing but an implicit contract that the citizens and the government have, where citizens basically compromise with their freedom, so the government provide them with certain kind of facilities. So this is what we can understand as a social contract. So the right to social contract is available to anyone capable of consenting. That is why the petitioners have said adults of any faith or no faith may engage in it. And also, no one group of people may define for another what marriage basically means. That means whether it is a marriage between two couple having similar sex or opposite sex should not be a matter of concern. And no contract nor forceful state action like imprisonment may curtail an adult's fundamental right to marry. Now, the question comes that what was the error which the petitioner has said were in the early judgment which should have been reviewed and rectified with the Supreme Court. So basically the petitioners have said that effectively due to the past judgment, as you know that further in the 2018 the same sex basically we can say union was decriminalized after the removal of section 377. So despite this, as the marriage right is not guaranteed to the same sex couple, effectively they said that it compels the young queer Indians to remain in the closet, as obviously there is no legality of their marriage, and it lead to living of them a kind of dishonest life. If they wish the joys of real family, that is something is not available to them. And also it is fallacious that under these facts and in the absence of fundamental right to marry or form a union, the rights to equal protection, dignity and fraternity are insufficient to justify judicial intervention. That means basically what they have said, that such kind of the judgments that has been given earlier by the Supreme Court, it basically is against the right to equal protection, as everyone should enjoy in the constitution, dignity and fraternity. And since these are not basically taken into cognizance, there is a ground for judicial intervention, and that is the reason or rationale behind the review petition. So that is all about this particular video. I hope you got the idea about the reason why Supreme Court has basically dismissed the review petition and what was the rationale of such review petition by the petitioners. Thank you.